All right, well, we now know the outcome of the healthcare ruling from the Supreme Court, but there are still so many legal questions. Let's bring in our legal guys. Avery Friedman, a civil rights attorney and law professor in Cleveland. Richard Herman, a New York criminal defense attorney and law professor. He joins us from Miami. Guys, I sat last night and read through Robert's opinion. Fascinating stuff. Obviously, this is historic for him personally, but let's talk first about the ruling on the individual mandate, because this is what confused people at the outset, and it's what a lot of people are still trying to get their heads around now, that it is not legal under the Commerce Clause, but is legal under the taxation authority of the federal government. Give it to me, Richard, in layman's terms.
In layman's terms, Poppy, the Affordable Health Care Law passes. The individual mandate is deemed constitutional, not on the grounds it was argued, not on the grounds it was argued by the government, but on other grounds, the power of Congress to tax. It's a broad, overreaching power that Congress has to enact taxation laws and statutes. That's what the Roberts Court relied upon, not on the Commerce Clause, to dismay of many of the judges who were in agreement with the majority. Right. Still, this ruling severely impacts future laws where Congress has enacted them by virtue of the Commerce Clause. And again, legal scholars will be debating this for a long time to come, but it's going to have a chilling effect, I think.
I don't know about that.
Avery, let's get to that, because I think in many ways you can see this ruling as both liberal and both conservative. What Justice Roberts wrote in his opinion is that if you enacted the individual mandate under the Commerce Clause, you would be making people do something, not just regulating what they buy, but forcing them to buy something. That's really the base of this. So what do you take? Obviously, you don't agree with Richard on this.
Well, I agree on the conclusion that it's constitutional. I think the conventional wisdom, of course, was that the likelihood of constitutionality of affordable health care had about as much chance as Sonny Corleone in a toll booth. But I think what Chief Justice Roberts did was do a little bit of constitutional rope-a-dope. What he did is he took a footnote argument, basically. The government actually did argue taxing power, and there were some scholars that said, yeah. And so what he did is he split the baby. Why? Because he wanted to look as if, for the millions of Americans who were affected by this, what is the legacy of the Supreme Court? What is the legacy of the Chief Justice? Interestingly enough, in today's Times, you saw a juxtaposition of Chief Justice Marshall, our greatest Chief Justice, with Roberts, but both of them had very different views on the Commerce Clause, and that's going to affect the future.
I do want to talk about something, guys. It's very important for anyone that lives in the basically 26 Republican-led states that oppose this. The ruling on the expansion of Medicaid. Okay, this is really seen as a win for those states, that the federal government, as Chief Justice Roberts put it, can't hold a gun to the heads of these states. It can't take away their Medicaid funding if they don't participate in expanding their Medicaid eligibility and spending more money to do this. What is your take on that, Richard?
That's right, Poppy. It cannot be a penalty. The Congress cannot impose a penalty upon states. They have to give them the option to participate or not. And this, I believe, is the most significant feature of the Supreme Court decision. This alone is going to hamper this particular law, and you really have to focus on this portion of the decision, because this is what's going to impact the majority number of people. 26 states, going to be very hard for them to vote for this if they are truly Republican and going to go along those party lines.
And Avery, we can tell you disagree with that. Address that quickly.
I absolutely disagree. I mean, the part of necessary and proper, other parts of Article 1, Section 8, every American should pull out their Constitution, look at the laundry list. On the Medicaid portion of it, yes, it certainly cannot be used as a penalty. That would be unconstitutional, but there's no question in my mind, even with the Republican governors and Republican state legislatures, there is no choice. Legislatures are going to have to deal with this. They are not going to be able to cut off citizens. It's not going to be, it's going to be a variation on what the ACA is. Look for Congress to modify that. There is no way that that's going to cut off care for the states that oppose it. No way.
I do want to tell everyone out there that has heard Mitt Romney and those that oppose it saying that if Romney is president, he will push to repeal it immediately, he does not have the power to do that. Congress would have the power, the only power that would be able to do that. And that's important to keep in mind as people listen to both candidates on this. Guys, thank you very much. As always, we'll have you back here in 20 minutes to talk about this interesting case. A woman suing a Little League player after she got hit in the face with a ball. Kid was 11.
Right.
Well, in New Jersey, a woman is suing a 13-year-old boy for hitting her with a baseball during a Little League game almost 2 years ago. Matthew Migliaccio told his dad he was warming up in the bullpen when the ball slipped out of his hand, sailed over the fence, and hit Elizabeth Lloyd. Matt's dad believes what his son told him and that this was just an unfortunate accident.
He said, we weren't screwing around, Dad. The ball slipped out of my hand when I threw it back, and it went over his head. Like, to him, this happens every day in Little League. Or I want these people to come to their senses and drop the case. It's insane.
All right, our legal guys are back. Avery Friedman in Cleveland and Richard Herman in Las Vegas. Avery, want to go to you first. What does the plaintiff, Miss Lloyd, what does she need to prove here? I'd assume damages and liability, right?
Well, he's got to show both. I mean, clearly there are damages all over the place. Elizabeth Lloyd, who got hit by Matthew's pitch, obviously has had reconstructive surgery, other continuing headaches, that type of problem. It's the real thing. The problem is the liability issue. I mean, clearly this was unintentional. Elizabeth's lawyer claims that Matthew, who was 11 at the time, said he did it on purpose. It's nonsensical. So I think there's a real question of whether or not there's going to be liability. Clearly, I think there was negligence somewhere along the line, but was it foreseeable? I don't think so.
And interestingly, this case was filed just 2 weeks before the statute of limitations ran out. In New Jersey, civil lawsuits for personal injuries have to be filed within 2 years. So that's an interesting point that may get taken into consideration. Richard, the plaintiff, Elizabeth Lloyd, wants $500,000. That's what she's suing for. And I look, there's actually precedent going back for this to a 1935 case in California's Supreme Court, right, about the assumption of risk if you're at a game.
Right. That's for professional baseball, and that's where assumption of risk is applicable. Here, though, they're alleging assault and battery, which is an intentional tort. And I think the lawyer who brought the lawsuit missed the boat on this, because if you sue for intentional tort, that's usually a disclaimer on any and all insurance policies. Number two, he was 11 years old, and to think that he could form the requisite mental intent to throw and intentionally hurt someone and yet hit someone in the face at the distance he was. I mean, the Yankees would have signed this kid up already. It's a ridiculous lawsuit. It's going to be knocked out.
That's
going nowhere.
Watch out. Going nowhere. Watch out, Jeter.
I like that.
Guys, quickly before we move on to the next case, quickly, how does this play out? Dismissed, go to trial, settlement?
Dismiss.
Settlement. It's going to resolve.
Okay, next case. This one is kind of wild. All right, so you've got this former waitress, Courtney Scaramella, filed the lawsuit against the owners of a sports bar where she used to work called O'Hara's in Westwood, California. She claims that she had to wear a uniform, that plaid skirt she thought was inappropriate. She claims that fans were placed on the floor to blow up waitress's skirt. She called it embarrassing, uncomfortable. O'Hara's response, they said, look, this suit has no merit. She was not fired. She quit her job. And just to note here, when she complained about this uniform, they changed the policy and took the uniform away, but then she says they cut her hours back and goes on and on. So what's your take on this, Avery? Does she have grounds for a case here?
Yeah, it's a vintage, classic retaliation under employment law. Look, I don't know what it is with men. How do they come up with these ideas about a short skirt? You know, remember that was like Britney Spears when she used to be cute? And then they attach Velcro to it so some drunken slob can rip it off of her. What a terrible, terrible idea. How demeaning, how humiliating for women. I think, and again, they're allegations, Poppy, allegations.
Absolutely.
If they can be proven, Courtney's case can be proven, then I think she's very, very strong in the outcome. It's a very serious matter, violation of both federal and state law.
Richard, I was reading some of the comments on news reports that people were writing in when they read about this case, and one of them said, free country, get another job. It's a very hard economy, so that's easier said than done, but I don't know, what's your take?
It's a ridiculous case. It's not a serious case.
What?
It's ridiculous. Listen, The woman is working there for 4 years. A change of ownership takes over. They're struggling in this economy to make money. Was she going to contribute to the owners to help them? No. They had to come up with an idea to generate sales. They implemented this. She did not have to work there. She could have left and got another job, yet she chose to stay. She chose to wear the skirt. She chose to check out at the cashier with the wind blowing. She wrote the letter, and they stopped it. This case, Poppy, is as stupid as the Little League case. It's going nowhere.
That's shameful. That's a shameful conclusion, Richard.
That's the facts.
I
That's
mean,
the hard
this
line.
is a clear violation of federal state law.
You got to be real.
I want to see you guys go to trial together and battle this one out. That would be entertaining.
You be the judge.
Well, you know what?
I am not adjudicating. I am not adjudicating this case, guys. Thank you as always. Pleasure to be with you. I watch you every Saturday, so pleasure to be with you. Thanks, guys.
Great working with you.
Take care.
Have a great weekend.